I've seen a probate sale nearly collapse over something the family never even knew to ask about. I'm Laura DiPaolo, Realtor with eXp Realty, and if you caught my last video on how probate works here in Florida, you already know the basics. Today we're going deeper into 3 mistakes that can quietly derail your closing and how to avoid them. Mistake 1, not checking whether the people handling your probate actually have real probate experience. This applies to both your attorney and your realtor. A lot of attorneys handle wills and estate planning, but that's different from actively managing a probate case through the court system, including the sale of real estate. Ask directly, how many probate estates have you handled? And do you have a team experienced in this if it's not your primary focus? The same goes for your realtor. Ask if they're probate certified and how many probate sales they've actually closed. This isn't a specialty most agents ever train in, and the wrong team on either side can cost you months and potentially thousands of dollars. Mistake 2, not confirming where each required filing actually stands before listing. Florida probate has several steps that each take time to move through the court, and assuming you're further along than you actually are is how sales get stuck. Here's a few for reference. The letters of administration, which gives the personal representative legal authority to act, can take about a month to process. There's also the inventory, which is the official listing of the estate's assets, which typically has its own filing deadline after the letters are issued. Then there's the notice to creditors. Once it's filed, it has a minimum 90-day window before that claim period is satisfied. And that timeline cannot be rushed no matter how motivated everyone is to sell. And if a creditor does come forward with a valid claim during that window, and this can happen on the 90th day, it has to be addressed before the estate can move forward, which can mean money the estate now owes gets settled out of the proceeds before anyone sees a distribution. That's exactly why confirming these steps early matters so much. Oh, and if any of these are skipped, delayed, or handled by someone unfamiliar with the process, a sale can get stuck under contract for months while it catches up, or the buyers simply back out, causing you to potentially sell for less. And it's not just a paperwork problem. Filing things out of order or late doesn't sit well with the judge overseeing the case, and let me tell you, you do not want to be on the judge's bad side. And that can create even more delays exactly when you can least afford them. Before I ever list a probate property, I confirm exactly where each of these stands. Don't just take someone's word that you have the green light. Ask to see it in writing from the court records. Mistake 3, pricing the house based on emotion instead of data. It's hard not to. This is often a family home, and it could feel wrong to price it like any other listing, but overpricing costs you time, and time works against an estate, especially with carrying costs, taxes, and multiple heirs waiting on a resolution. I build clear condition-based pricing scenarios so heirs know exactly what the house is worth as is versus what light updates could bring before we ever set a number. These are the kind of details that make or break a probate sale, and it's exactly why I work every one of these transactions alongside a trusted probate attorney. If you've inherited a property in Florida and need help with the sale, call me directly at 813-951-0657. I'm Laura DiPaolo with eXp Realty, and I'm here to help you make the process as smooth and stress-free as possible. Keep an eye out for my next probate video where we'll cover exactly what a personal representative can and can't do.